Welcome back. I've been thinking about this one since I first read the script, and what strikes me isn't the scale of the betrayal, it's the restraint. Most people, given a second life, would arrive swinging. This protagonist arrives with a pen. She hands her enemy the rope and waits for the probate court to pull it tight. That is the kind of cold that stays with you. You're watching Historical Manhwa. The smell of carnations was the first thing that came back. Not roses, not lilies, the way expensive funerals preferred. Carnations, pale pink ones with brown edges where the florist had kept them too long in refrigeration, the petals stiffening at the tips like paper that had been wet and dried wrong. The smell was thick and slightly medicinal, the way flowers got when they were performing grief rather than expressing it. Vivian Liang had been dead for 11 months the first time she smelled those carnations. Now she was smelling them again, and her hands were folded in her lap, and the velvet of the funeral parlor chair was pressing its pattern into the backs of her thighs through the fabric of a dress she had not worn in what felt like a different century. She looked down at her hands. The nail on her right index finger had a chip in the corner, a small white V of missing polish that she remembered distinctly. She had chipped it on the edge of her car door that morning before the call came. Before everything. She was 31 years old. She was also, in every way that mattered, not. The room around her was what she remembered. Low lighting, the kind that came from floor lamps with amber shades rather than overhead fixtures, designed to make everyone look slightly more alive than they felt. Cream wallpaper with a thin gold stripe, a low mahogany table with a tray of untouched water glasses. The funeral director, Mr. Paulson, standing near the doorway with his hands clasped and his expression calibrated to a perfect frequency of respectful neutrality. He was good at his job. Aunt, her father's casket was at the far end of the room, closed, which had been a battle. Her stepmother Renata had wanted it open. Vivian had refused. In her first life, she had refused quietly, apologetically, the way she did everything in those years, always softening the corners of her own preferences so they wouldn't cut anyone. Renata had pushed back. They had compromised on closed, but Vivian had walked away feeling like she'd lost. She wasn't going to feel that way this time. She was going to feel very little, actually, for quite a while. That was the plan. Marcus Liang had died on a Tuesday, which felt wrong. He was a man who had operated in quarters, in fiscal years, in annual meetings, and dying on a Tuesday in mid-October had an accidental quality to it, as though he hadn't quite gotten around to scheduling it properly. He had been 67, healthy on paper, and then he had been in a hospital in the cardiac unit for 4 days, and then he had been gone. Vivian had been at his bedside for 3 of those 4 days. On the 4th, she had gone home to shower, to feed the cat she no longer owned, to sit on her kitchen floor for 20 minutes because her legs had stopped working correctly, and that was when he had left. She had not been there. She had carried that for 11 months, through everything that came after, through the dissolution of what she'd thought was her inheritance, through the legal maneuvering, through the document she'd signed that she should never have signed, through the morning she'd stood outside a courthouse in February rain, while Celeste Liang, not Liang anymore, Celeste Hargrove, née Liang, else Vivian's stepsister by marriage and nothing else, walked past her with a folder of documents, and did not look at her even once. Vivian had stood in that February rain and understood she had lost everything her father built. Every account, every property, the family firm, the controlling stake in Liang and Associates Asset Management. Gone through a series of legal maneuvers so precise, so patient, so thoroughly rooted in her own ignorance of probate law that she had not even seen it coming until she was already through the door and the room was empty. And then she had died. That was the part she was still processing in the calm, slightly outside of her body way. She'd been processing everything since she opened her eyes this morning in her old apartment with the chip on her fingernail and the carnation smell already reaching for her through memory. Not violently, not dramatically. A car accident, the kind that happened to people all the time on wet roads in February, and she had been tired. She had been so thoroughly used up by grief and legal defeat, and the specific humiliation of watching someone dismantle your inheritance piece by piece while calling it estate administration. And perhaps she had not been as careful as she should have been. Perhaps. She preferred not to examine that part too closely. The point was, she was here now, 11 months early. Out back in the chair with the velvet pressing into her thighs and the carnations performing their damp grief, and Mr. Paulson at the door with his calibrated expression, and Renata somewhere in the back hallway crying in the specific key she cried in when she wanted to be heard. And Celeste. Celeste was here too, of course. She had arrived 20 minutes after Vivian, which was already a statement. Celeste was the kind of person who made statements with timing. She was 34, 3 years older than Vivian, and she had Renata's long neck and her biological father's blunt intelligence, and she had spent the last decade becoming exactly the kind of woman who knew how to stand in a room and make every other woman in it feel slightly wrong about their posture. She was in black, a wool crepe that probably cost what Vivian's first car had cost, and her hair was in a low twist, and she had already, Vivian noticed, made 2 phone calls from the hallway. To whom? Vivian knew. In her first life, she had not known until it was far too late. She knew now. She sat with that knowledge the way you sit with a hand of cards you've been dealt in a game you've already played. Not excited. Not burning. Just aware of what you're holding and what it means and what you're going to do with it. Nothing yet. That was the answer. Nothing yet. The funeral director drifted toward her with the practiced float of someone who spent their professional life navigating rooms full of grief. "Ms. Liang, there are a few paperwork items when you're ready." He said it softly, the way they said everything, with that particular gentleness that funeral homes used like anesthesia. "Of course," Vivian said. Her voice came out steady. She was slightly surprised by that. She stood and smoothed the front of her dress, and did not look toward the casket, and followed him through the amber light to a small side office with a desk and 2 chairs, and a box of tissues placed with mathematical precision in the corner of the desk blotter. She sat down across from him, and he opened a manila folder, and she thought, with the part of her brain that was already operating 11 months in the future, the will reading is in 4 days. The estate attorney is Gerald Fitch of Fitch Barlow and Cole, who has been her father's attorney for 18 years and who is, despite his white hair and his grandfather energy, not a man you can charm or maneuver without consequence. She knew this because she had tried in her first life, and he had been very polite about how completely he had failed to be moved. The will, she knew, named Vivian as primary beneficiary of 60% of the estate, and Renata as beneficiary of 25%, with the remaining 15% distributed to a charitable foundation Marcus had established years ago. Standard, straightforward, clean. What was not in the will, because it was not the kind of thing you put in a will, was the understanding that had existed between Marcus and his attorney about the executor designation. He had intended to name Vivian. He had in fact drafted a codicil to that effect. He had simply not signed it before his cardiac event. The unsigned document was in Fitch's files, and it had no legal weight. In her first life, Vivian had walked into that will reading and fought for the executor role, had argued her qualifications, had presented herself as the obvious choice. She had been grieving and raw and unpolished in exactly the way that people found sympathetic in ordinary situations and found threatening in legal ones. She had said the wrong things in the wrong tone. Celeste, who had a finance background and a demeanor that was all clean lines and soft confidence, had made a quiet case for herself through Renata, who was technically a beneficiary and therefore had standing to make the suggestion, and Gerald Fitch had found it reasonable, and the probate court had found it reasonable, and Vivian had found herself on the outside of the process, receiving updates about her own inheritance as though she were a guest. That was the first mistake. Not the biggest one, but the first. The biggest one was trusting that Celeste would manage the estate correctly. Not generously, not even fairly, but correctly in the legal sense, in the way that estate executors were required to behave under the probate code. She had not done that. She had done the opposite of that. She had used the executor role as a lever, liquidating assets at prices below fair market value to buyers who turned out, when Vivian finally hired her own attorney and began to trace the documentation, to be entities connected to a private holding company that Celeste had a financial interest in. She had taken executor fees that exceeded what the estate code allowed. She had distributed assets from the estate to Renata before the estate was fully administered, and all debts and taxes were settled, which was a technical violation of fiduciary duty. She had made investment decisions with estate funds that were not authorized under the will's terms. All of it was documented. Or rather, all of it would be documentable if someone were watching from the beginning. Vivienne was going to be watching from the beginning. Ms. Liang, the funeral director, was looking at her with mild professional concern. She realized she had not responded to whatever he had just said. "I'm sorry," she said. "It's been a long few days." "Of course," he said gently. "I was just saying these are the forms for the death certificate order. Oh, we'll need several certified copies for the estate process." She took the pen he offered and signed where he indicated. Her handwriting was slightly different from how she usually wrote it, a little more controlled, a little less fluid. She had been through so much since this pen and this signature that she had apparently come back slightly altered in small ways. That was fine. She could work with that. She needed 12 certified copies, she told him. He raised his eyebrows slightly. Most families ordered 4 or 5. She explained calmly that she had been advised by counsel that complex estate situations often required more. And he made a note, and she returned to her chair in the amber light with a legal pad she had pulled from her bag, and she began to write. Not everything, just the framework, dates, names. Here's the sequence of events she needed to allow to happen, and the ones she needed to interrupt, and the ones she needed to document from the moment they began. The first thing she wrote was, "Let her be named Executor." She underlined it twice. Then she thought about it for a moment and added, "Wait." She was good at waiting. She had gotten much better at it. In the months before the car accident. In the long education of watching everything she'd failed to protect dissolve into documentation she couldn't fight. She had learned patience the painful way, the way you learned most useful things. Now she was going to use it the other way. Celeste came into the room 20 minutes later, the wool crepe moving correctly, the low twist immaculate, the expression carrying the precise calibration of appropriate family grief. She sat down on the other side of the mahogany table and she said, "Viv," and the familiar diminutive landed like a feather, light and practiced. "Celeste," Vivienne said, "how are you holding up?" It wasn't quite a question. It was a performance of a question, the kind where the asker already knows the answer is fine, I'm fine, we're all doing our best, and has structured their face accordingly. "I'm managing," Vivienne said. Celeste looked at the legal pad in Vivienne's lap. Her eyes moved there and then back up, and something very small happened in her expression. A flicker, a brief recalibration. Celeste was not stupid. Vivienne had never made the mistake of thinking she was. The mistake she'd made was thinking that not stupid was the same thing as unbeatable. "Gerald Fitch's office called," Celeste said. "He'd like to meet with us, together, before the formal reading, to go through the administrative aspects. He wants to discuss the executor question." "I know," Vivienne said. "I spoke with his office this morning." Another small flicker. "Already?" "Yes." Celeste let a breath in through her nose, slow and controlled. "I thought we might present a united front," she said. "Given the complexity of Dad's holdings, you have the beneficiary position, which is the most important thing. The executor role is really just administrative." She paused just long enough for that to land before adding, "And honestly, with your design work, with everything on your plate already, it might be a relief not to have to manage the paperwork." This was the pitch, delivered word for word as Vivienne remembered it, asked with the same soft emphasis on relief and the same dismissal of the executor role as merely administrative. It had worked the first time because Vivienne had been grieving and exhausted, and because Celeste was good at the particular skill of making concessions sound like a gift. Vivienne looked at her stepsister for a moment. She had a very specific memory of standing outside that February courthouse and watching Celeste walk past her with the folder of documents and the absolute absence of any acknowledgement. She had stood in the rain for 6 minutes after Celeste was gone, just standing, the cold water coming through her coat, trying to understand how someone could do what Celeste had done and then simply walk. "That's thoughtful," Vivienne said. Let's see what Gerald recommends." Celeste's expression settled into something satisfied but carefully restrained. "Of course," she said, "whatever's best for the estate." Vivienne smiled at her stepsister for the first time since she had come back to this particular morning and this particular amber-lit room. And it was not a warm smile, and it was not a cold one. It was the kind of smile you offered when you had just decided not to correct someone's assumption because you needed them to keep assuming. The will reading was on a Friday morning. Gerald Fitch's offices were on the 31st floor of a building in the financial district, the kind of offices that had been designed in an era when law firms believed that dark wood and leather conveyed authority and had simply never redone them because they still did. The carpet was navy and thick, and the windows looked east over the water, and the conference table could have seated 12, but there were only 5 of them. Vivian, Renata, Celeste, Gerald Fitch, and a junior associate named Kim, who was there to take notes and who had the specific expression of someone concentrating very hard on being unobtrusive. Renata had cried in the elevator. Celeste had offered her a handkerchief, the cloth kind, which Vivian had noticed. The cloth kind were a choice. They communicated a certain kind of preparation. Gerald Fitch read the will in the dry, measured cadence of someone who understood that speed was a kindness in these situations. The distribution was as Vivian remembered it. 60, 25, 15. The value of the total estate was approximately $48 million, which had been Marcus Liang's life's work. 11 properties, 5 investment accounts, the 42% controlling stake in Liang and Associates, a private collection of Asian art that had been assessed at close to $3 million on its own. When he reached the executor section, Fitch paused in the way he paused, the way Vivian remembered. Your father had expressed a wish to me, verbally, regarding the executor designation, he said. However, the relevant codicil was not executed prior to his passing and carries no legal weight. In the absence of a valid executor designation in the will itself, the role falls to the probate court to assign, typically from among the primary beneficiaries. Renata looked at her hands. Celeste looked at Gerald Fitch with an expression of careful attentiveness. I'd like to make a suggestion, Celeste said. If I may. Fitch gestured for her to proceed. I'm aware that Vivian is the primary beneficiary and that her interests are the ones most directly at stake here. I want to be sensitive to that. But given the complexity of Dad's holdings and the fact that I have a background in corporate finance, I think I might be well positioned to take on the administrative responsibilities. It would take that burden off Vivian during what I know is an incredibly difficult time. She paused. I'm not suggesting anything about the distribution or Vivian's rights, just offering to shoulder the operational work. It was beautifully done. Vivian had to acknowledge that, internally, the way you acknowledged an opponent's good move before you began to dismantle it. Only the framing as service rather than ambition. The explicit deference to Vivian's interests, the casual drop of corporate finance, the word burden. In her first life, Vivian had pushed back at this point, had said she felt the executor role was something she wanted to handle personally, and the conversation had become slightly uncomfortable in the way conversations became uncomfortable when one person kept insisting and the room had already decided. She had lost the room before she finished her first sentence. This time, she said nothing. Fitch looked at her. Vivian, you have standing as the primary beneficiary to weigh in on this. I appreciate Celeste's offer, Vivian said. She said it calmly, with genuine-sounding warmth, the tone of someone who is taking the gift they'd been offered. I'll trust the court's judgment. Fitch's eyebrows moved a fraction. He had expected her to push back. She knew he had expected it because she remembered the look on his face the first time she had pushed back, that micro-expression of bracing. Very well. We'll proceed with the petition for appointment. Given the circumstances and Ms. Hargrove's qualifications, I expect the court will find her appointment appropriate. Celeste said, Thank you, Gerald, with the measured warmth of someone accepting an obligation rather than a victory. She was good. Vivian looked out the east-facing windows at the water. The October light was doing something complicated on the surface, breaking into strips where the wind had riffled it. She was already thinking about Phase 1. She needed to open a file. Not a physical one yet. Though she would have physical ones eventually, organized and tabbed and dated, the kind of documentation that looked good in a court exhibit. Right now she needed a mental file, a running inventory of every action Celeste was going to take as executor and what category of potential breach it fell into. There were 3 broad categories of executor misconduct under most state probate codes. The first was self-dealing, where the executor engaged in transactions that benefited themselves or parties connected to them at the estate's expense. The second was breach of fiduciary duty in a more general sense, which covered negligence, unauthorized investments, improper distributions, failure to maintain estate property. The third was failure to account, which meant not keeping adequate records, not filing required accountings with the court, not providing information to beneficiaries. Celeste, in her first life, had committed violations in all three categories. She had been careful enough that none of them were immediately obvious. She had not been careful enough to avoid leaving evidence, because no one who was committing financial misconduct inside an estate ever was truly careful enough. Because estates generated paper, always, and paper left trails, always, and the only question was whether anyone was looking. Vivienne was going to look. She had spent, in the months after Celeste's executor appointment in her first life, approximately $40,000 on an estate litigation attorney who had been very good and very thorough, and had ultimately told her that while the evidence of misconduct was substantial, the time and cost of litigation made recovery uncertain, and that she might be better positioned to negotiate a settlement. She had refused. She had been offered a settlement. She had refused that too. And then the accident had happened, and all of it had ended. This time, she was not going to pay $40,000 to an attorney to reconstruct a paper trail. She was going to build the paper trail herself from the beginning, and she was going to hand it to the court when it was complete. This was legal. This was her right as a beneficiary. She had learned that in those months of expensive legal education. As a beneficiary, she was entitled to receive regular accountings from the executor. She was entitled to request information about estate assets and their management. She was entitled to petition the court for the executor's removal if she had grounds, which were defined in statute, which she had read so many times in the months before her accident that she could have recited them in her sleep. Grounds for executor removal: failure to perform duties, mismanagement of estate assets, self-dealing, failure to account, incapacity, and a catch-all provision that most attorneys described as conduct that is contrary to the interests of the estate. Celeste was going to give her all of those. Vivienne just had to be present to record it. She opened an account that afternoon with a secure cloud storage service, and she titled the first folder with the date, and she uploaded the will, the executor petition documents, and the death certificates. She bought a small recording device that she kept in her bag. She began keeping a daily log, time-stamped, noting every communication she had with Celeste or with the estate attorney's office. She bought 3 copies of a standard reference on estate administration under state probate law, the kind of reference that attorneys and CPs used, and she read all 3 of them cover to cover over the next 2 weeks, annotating as she went. She also, and this was the part she had not been able to do in her first life, because she had not known to do it, she also made contact with a forensic accountant. His name was Dennis Yu. He was 52, compact, and wore glasses that sat slightly crooked on his nose, and he had spent 20 years doing financial forensics for insurance companies and law firms, and he had a particular subspecialty in estate fraud. She had found him not in her first life, but in the months after. Too late. Even when her attorney had recommended him as the person who could have helped had they engaged him earlier, she was engaging him earlier. She called him on the Monday after the will reading, and she said, "My name is Vivienne Liang. I am the primary beneficiary of my late father's estate. An executor has been appointed who I have reason to believe may not administer the estate in accordance with her fiduciary obligations. I would like to retain you to provide ongoing analysis of the estate accountings as they're produced, and to advise me on what to look for." There was a pause on the other end. Dennis Yu was not a man who dealt in alarm or drama. She would learn that about him. He processed information at his own pace, and he spoke when he was ready and not before. "Do you have specific concerns at this point?" he said. "Same, or is this precautionary?" "Precautionary," she said, "with specific concerns that I expect will become documentable over time." Another pause. "I'd want to understand the estate's asset composition and the executor's background." "I can send you everything I have tonight." "All right," he said. "Send it over. We'll talk Thursday." She sent him the estate documents that night, sitting cross-legged on her kitchen floor with her laptop and a cup of coffee that had gone cold an hour ago. The specific domestic scrappiness of doing something important in an unsuitable setting. Her cat, who did not exist yet in this life, would have been climbing onto the keyboard by now. She found herself aware of his absence as a shape, the negative space of him. She pushed that aside and finished sending the documents. She slept 4 hours. Which was more than she expected. The weeks after a death in a large estate were a particular kind of administrative weather. There were notices to be sent, creditors to be identified, accounts to be frozen and then unfrozen in the right sequence. Celeste handled it all with the smooth efficiency of someone who had either done this before or had done extensive preparation. And Vivian received the communications, acknowledged them, raised no objections, and logged everything. She was watching for the pattern. In her first life, the pattern had been Celeste moved quickly, more quickly than the estate code technically preferred, on the asset liquidations. She had sold 2 of the 11 properties within the first 4 months of the estate opening at prices that were later assessed to be 15 to 20% below fair market value. The buyers, when traced, were subsidiaries of an entity called Ridgeline Capital Partners, LLC, which was registered in Delaware and had a remarkably thin paper trail considering the size of the transactions, and which, when traced further by her first life attorney, had a financial structure that connected, through 2 layers of holding companies, to a private fund that listed Celeste Hargrove as an investor. That was the self-dealing. That was the clearest violation and the hardest one to prove without the full corporate structure documentation, which was why her first life attorney had estimated high costs and uncertain outcomes. Vivian had a different plan for that part. She had a contact at the Delaware Secretary of State's office who processed corporation filings, a woman named Bet who was not corrupt, simply human, and who Vivian had spent 45 minutes talking to on the phone in a different context in a different life. Learning things about public record requests that she had not known before. Delaware corporation records were public. You could order them, you needed to know what to ask for, and you needed to be patient with the processing time, but you could do it. And the records would show you the registered agent, which would lead you to the filing attorney, which would lead you, if you were patient, to the structure of ownership. She filed the first public records request 3 weeks after the estate opened. While she was waiting for those records, she was also watching the inventory. Estate administration required the executor to compile a complete inventory of estate assets within a period defined by statute, typically 60 to 90 days depending on the state. Vivian had requested in writing, through her own attorney, that she receive a copy of the inventory when it was filed with the court. This was her right as a beneficiary, and Celeste could not refuse it. She hired her own attorney in the 4th week. Not the same attorney she'd hired in her first life, who was good, but had come in too late and spent too much time on strategy and not enough on documentation. This time she hired a young woman named Sarah Patel, who had been 2 years behind Vivian in law school, whom Vivian hadn't known well but had tracked through professional channels, and who had, in the 4 years since graduated, become precisely the kind of estate litigator who was going to terrify Celeste when the time came. She was 30. She was quiet in meetings and ferocious in documents. And she had a particular gift for the kind of motion practice that tied opposing parties in knots by being technically impeccable. Vivian called her and said, "I want to retain you on a monitoring basis. The executor of my father's estate has been appointed, and I want someone watching the proceedings from a legal standpoint." Sarah Patel had paused, the way good attorneys paused when they were calibrating something. "You expect problems?" "I expect nothing to be visible for some time," Vivian said, "and then I expect significant problems. I want to be in a position to move when they become visible." That's an efficient way to approach it. It's the only way that makes sense. She met with Sarah and Dennis Yu together in the 6th week, in a conference room at Sarah's office that had the generic quality of rooms designed not to distract from work. Neutral colors, a whiteboard, bad coffee, and a carafe that had been sitting on the warmer too long. Vivian sat at the head of the table with her organized folder and her legal pad and explained what she knew, what she expected, and what she needed each of them to do. Dennis would analyze every financial document produced by the estate as soon as she received it. He would flag any transaction that appeared to be below market value, Any fee that appeared to exceed statutory limits, any investment that appeared unauthorized under the will's terms. He would build a running financial analysis file that Sarah could use as an exhibit. Sarah would ensure that every right Vivian had as a beneficiary was exercised, on time, in writing, so that there could be no question about her standing when the time came to file. She would also begin researching the comparable sales data for the estate properties in their respective markets so that when the liquidations happened, they would have the market data ready to compare. Vivian would maintain the log and manage the documentation, and she would do one other thing. She would be cooperative and pleasant, and completely unalarming to Celeste. This was the crucial part, the part that required the most discipline. In her first life, she had been cooperative because she was overwhelmed and grieving and did not understand what was happening. In this life, she was going to be cooperative because she understood exactly what was happening and she needed Celeste to continue happening it. But an executor who thought she was being watched became careful. An executor who thought the primary beneficiary was trusting and slightly passive and too consumed by her grief to be paying close attention to the asset values made bolder decisions. That was the nature of this kind of fraud. It depended on the inattention of the people it was being committed against. Vivian was going to give Celeste all the inattention she needed. She called Celeste in the 7th week and said, "I just wanted to check in. I know you have a lot to manage and I want you to know I appreciate everything you're doing." Celeste said warmly, with the specific warmth of someone who has been expecting an obstacle and is finding a clear road instead. "It means a lot to hear that, Viv. I know this is such a hard time. Oh, I just want to do right by Dad's legacy." "I trust you," Vivian said. She said it cleanly, with full eye contact through the phone somehow, the way you delivered something you knew the other person needed to believe. She heard the small sound of Celeste exhaling. "Thank you," Celeste said. The Delaware records came in the 10th week. There were 17 pages of corporate filings for Ridgeline Capital Partners, LLC, and the registered agent was a firm called PBO Corporate Services, and the filing attorney was a man named Gregory Marsh from a small firm in Wilmington. And it took Vivian 3 additional public record requests, 2 weeks of waiting, and 2 hours with Dennis Yu on a Tuesday evening to trace the ownership structure through 2 layers of holding companies to a Wyoming LLC called Brightview Holdings. And the sole member of Brightview Holdings, according to its formation documents, was a trust. And the trustee of that trust was a woman named Margaret Hargrove, who was Celeste's mother-in-law, not Celeste directly, her mother-in-law. One additional step removed. Dennis Yu pushed his crooked glasses up his nose and said, "That's not going to be enough on its own." "I know," Vivian said, "but it establishes the connection if you can get anything else." "I know," she said, again. She had learned, in her first life's expensive legal education, that estate fraud cases were built like buildings. Foundation first, then frame, then walls. The corporate structure was foundation. She needed transactions, financial records, communications if she could get them. She needed the inventory and the first accounting. The inventory arrived in week 12. It was 104 pages, filed with the probate court and copied to Vivian's attorney as required. She read it the evening it arrived, sitting at her kitchen table with 2 highlighted pens and her legal pad, going through it with the careful attention of someone who knew what was there and was finding where it had been recorded. 3 things were missing. The first was a set of 6 lithograph prints from the art collection that she knew existed because she had seen them in her father's study for 20 years and because they had been listed in the insurance records she had obtained copies of. They were not individually valuable, perhaps $18,000 for the set at fair market, but their absence from the inventory was a fact. Executors were required to identify, preserve, and account for all estate assets. Failure to include known assets in the inventory was a technical violation of fiduciary duty. The second was a vehicle, a late-model sedan that Marcus had kept at one of the commercial properties, which appeared in the vehicle registration records but not in the inventory. The third was a promissory note. Her father had loaned money to a business associate years ago, $45,000 still outstanding, documented in Marcus's files, which Vivian had photographed before those files had been transferred to the estate attorney's office. The promissory note was a receivable, an asset of the estate. It was not in the inventory. She photographed the relevant pages of the inventory and emailed them to Dennis and Sarah that night with a 2-paragraph summary noting the 3 discrepancies. Dennis responded at 11 p.m. with a brief acknowledgement. Sarah responded at 7 the next morning with a memo she had already drafted, noting the specific statutory sections that governed inventory completeness requirements. They were building. The first property sale happened in month 4. Vivian knew it was coming because she'd known it the first time, and because Celeste's pattern was to move on the residential properties first, before the commercial ones, on the theory that residential sales were less scrutinized. The property was a house in the northern suburbs, 5 bedrooms, a generous lot, purchased by Marcus 23 years ago as an investment property and managed since as a rental. Its assessed value for tax purposes was $1.2 million. The comparable market analysis that Sarah's office had commissioned from a licensed appraiser showed a fair market value of approximately $1.65 million. It sold for $1.18 million. The buyer was an entity called Northgate Properties, LLC. Vivian already had the Delaware filing for Northgate Properties in her folder, pulled 6 weeks earlier in anticipation. Its registered agent was PBO Corporate Services. Its filing attorney was Gregory Marsh. She sat with that for a moment, the cold clarity of it. Then she sent it to Dennis and Sarah and said, "First one?" Sarah's response, noted and documented. "Not yet." Right. Not yet. The second property sold 2 months later. Commercial this time, a small mixed-use building downtown. Fair market value per their appraiser, $2.4 million. Sale price, $1.85 million. Now, a buyer or a company called Lakeview Commercial Holdings, LLC, registered in Nevada. Registered agent, a different firm. Filing attorney, a different attorney in Chicago. But the sole member of Lakeview Commercial Holdings, according to Nevada's public records, was another trust. And the trustee of that trust was the same Gregory Marsh who had filed the Northgate documents. That was the connection. He was not always the filing attorney. Sometimes he was the trustee. He was the structural architect, the person who built the shell companies and then stood inside them in a different role when needed. That was 2 properties. That was approximately $1.05 million in sale proceeds that should have come to the estate and did not. 60% of $1.05 million was $630,000 that should have flowed to Vivian's share and had instead been skimmed through undervalued transactions. She was not angry about this in the way she had been angry in her first life. She had been burning in her first life, the hot, specific fury of someone who had been stolen from. Now she felt something colder and more useful, the satisfaction of watching a pattern complete itself in a way that made it legible. This was not theft yet, not legally documented theft. It was the pieces of theft assembling themselves in her folder. She needed 4 more things. She needed a 3rd property sale, because patterns were easier to prove than isolated transactions, and because the 3rd sale would give her enough comparable data to make a compelling case for systematic below-market disposition. She needed the first annual accounting, which was due at the 1-year mark of the estate's opening, which would either reflect accurate records or it would not. And if it did not, that was a separate category of breach. She needed evidence of the excess executor fees, because Celeste was taking a percentage fee that was above what the state probate code allowed for an estate of this composition, which was something Dennis had flagged in week 20, running the numbers against the estate value and the statutory fee schedules. And she needed 1 communication, just 1. Something that showed Celeste knew what she was doing was improper. That last one was the hardest. People who committed estate fraud were generally careful about not writing things down in plain terms, but they were not always careful in every context. As they sent texts, they didn't think through. They made phone calls that got noted. They said things at family events that landed in a witness's memory. Vivian had something in mind. Renata had been, in the years before Marcus died, increasingly confiding in Vivian in the tentative, slightly apologetic way of a woman who had spent most of her second marriage aware that her husband's biological daughter was not entirely certain of her. They had not been close, but there had been warmth, the specific warmth of 2 people orbiting the same center. And Renata, who was not a subtle woman, had in the months after the estate opened begun to seem vaguely discomfited by some of Celeste's decisions. She had not said anything explicit. She had made the expressions of someone who wanted to, but couldn't quite. In her first life, Vivian had not paid enough attention to Renata's expressions. She invited Renata to lunch in month 6. Not the kind of expensive lunch that made things formal, but the neighborhood kind. The Italian place near where Renata lived that Marcus had liked, with the paper tablecloths and the good bread and the lighting that made everyone look slightly warmer. She ordered wine. She let Renata talk about Marcus for 40 minutes, the way Renata needed to, the memories tumbling out in no particular order, the way grief organized itself in conversation. And then, carefully, she steered. "I sometimes wonder," Vivian said, refilling Renata's glass, "how Daddy would feel about some of the estate decisions. The property sales. I know Celeste is doing her best, but those suburban properties were so personal to him. He'd had that Oakfield house since before I was born." Renata's expression shifted. "I know," she said, and then stopped. "She's consulting you on those decisions?" Vivian asked gently. "Not really." Renata looked at her wine glass. "I mean, she tells me after. Not always before." A pause. "She did say something once about the Oakfield sale. She said the timing was important, that there was a buyer who needed to close quickly. A specific buyer she knew?" Renata blinked. She didn't say that directly, but she mentioned that it was through a group she'd worked with before. Vivian set down her wine glass and looked at Renata with what she hoped appeared to be gentle concern, and was actually the focused attention of someone receiving a piece of evidence. "A group she'd worked with before," she repeated. On what kind of projects?" "She didn't say." Renata's voice had gotten slightly smaller. She understood dimly that this conversation had moved somewhere, even if she couldn't name where. "Vivienne, is something wrong? Should I just want to make sure everything's being handled correctly," Vivian said. "For both of us. You're a beneficiary too." Renata looked at her hands. Then she said, Celeste has always been, and stopped again. "What? Efficient," Renata said finally, in the tone of someone who had chosen the diplomatic word deliberately. That was not a document, but it was a thread. If it ever came to court, it was a witness who could testify to what Celeste had said about the buyer for the Oakfield sale. It corroborated the timeline and the relationship. It would not win a case on its own. It would sit in the corner of the courtroom and be useful. She logged the conversation in her file that evening, time-stamped, with a note that Renata had been present and lucid, and that the relevant statements had been made voluntarily. Month 7 brought the executor fee accounting. This was where Dennis Yu shone. He was, at his best, the kind of accountant who read a fee schedule the way a diagnostician read an imaging scan, systematically, from the center outward, annotating as he went. He spent 4 days with the estate's financial records, which Vivian had obtained through Sarah's formal beneficiary information requests, and he produced a 30-page memorandum with appendices. The executor compensation under state probate code was calculated as a percentage of the estate's assets under management, or on a tiered schedule that decreased as the estate value increased. For an estate valued at approximately $48 million, the maximum allowable statutory fee was approximately $240,000 over the course of administration, adjusted for the complexity factors that the code allowed. Celeste had already withdrawn $312,000 in executor compensation over 7 months. That was $72,000 above the statutory maximum, and administration was not complete. In addition, Celeste had billed the estate for expenses that Dennis classified as either not properly estate-related or in excess of what the code allowed. He had travel expenses for a trip to San Francisco that corresponded to dates when Vivian's research had placed Celeste at a real estate conference rather than on estate business. Professional service fees paid to an accounting firm that, when traced, turned out to be a firm where Celeste's husband had a professional relationship. The total excess, in Dennis's analysis, was approximately $94,000. He included in his memo the relevant statutory citations and an expert opinion, which he had drafted in language that could be submitted to the court, that the fee schedule had been materially exceeded, and that several of the expense billings appeared to constitute improper charges against the estate. Vivian read the memo twice. Then she sat very still for a few minutes with her hands flat on the kitchen table. $94,000. That was just the fee excess. That was before the property underselling. That was before the promissory note that had still not been collected or even acknowledged in the estate's records. That was before the missing inventory items. She sent Dennis a response thanking him for the memo and asking him to convert his analysis into a format that could be attached as a court exhibit. She sent Sarah a separate email asking her to begin drafting the petition. Sarah responded within an hour. "Which grounds do you want to lead with?" Vivian typed, "Breach of fiduciary duty, self-dealing, failure to account, all three." Sarah, "That's a strong filing. When do you want to move?" Vivian looked at the date. Month 7 of the estate. The annual accounting was due in 5 months. She wanted the annual accounting first. She wanted whatever was in that accounting to be on the record before she moved, because an annual accounting that reflected Celeste's management practices would either be accurate and therefore damning, or it would be false, and therefore an additional ground for removal. She typed, "When the annual accounting is filed." Sarah, "Understood. I'll have the draft ready to file within 48 hours of receiving it." The third property sale happened in month 9. She had almost stopped expecting it. The estate had been quiet in month 8, or appeared quiet, which was different. There had been no major dispositions, no significant movements in the accounts. Celeste had, perhaps, become slightly more measured, the way people became measured when they thought they were getting away with something and wanted not to overdo it. Month 9. Also a commercial property in a neighboring city. Appraised by the estate's own appraiser, Celeste's appointed appraiser, at $3.1 million. Listed on the market for 2 weeks, a remarkably short time for a commercial property of that value. Sold to an entity called Meridian Property Group, LLC, a Colorado corporation, for $2.62 million. The gap was $480,000. Sarah's office had commissioned a second appraisal on this one in anticipation, 2 weeks before the sale, because they had been tracking the estate's property movement, and this listing had appeared in the public real estate records. Their appraiser valued the property at $3.3 million. The gap between the fair market value and the sale price was $680,000. Colorado did not have the same public record depth as Delaware or Nevada, and it took Dennis Yu 10 days to trace the ownership of Meridian Property Group through a legitimate registered agent to a person rather than another layer of corporate structure. The person was a man named David Hargrove, Celeste's husband's younger brother. Not the mother-in-law this time, the brother-in-law. She had varied the structure of the self-dealing. That was intelligent, and she would have been more intelligent if she had varied it further, if she had used entities with no traceable human connection to her family. But the web she had built was small, and webs were visible when you looked at them from the right angle. Vivian added the Colorado records to the folder. She now had 3 below-market sales totaling approximately $2.2 million in undervalued dispositions, and all to entities connected to the Hargrove family through various layers of corporate structure. She had Dennis's fee analysis showing $94,000 in excess charges. She had the 3 inventory discrepancies. She had Renata's recollection of Celeste mentioning an existing buyer relationship. Month 11 brought the annual accounting. It was 167 pages. She received it on a Thursday afternoon, and she sat down with it that evening and did not get up from the table until after 2 in the morning. She went through it with the 3-colored highlighting system she had developed. Red for items that appeared incorrect or incomplete, yellow for items she needed Dennis to analyze, blue for items that conflicted with information she had from other sources. By 2 a.m., there were 43 red marks, 61 yellow marks, and 17 blue marks. The blue marks were the most important. They were places where the accounting's numbers did not match the numbers in documents she had obtained independently, bank records she'd received through Sarah's formal requests, property records from county assessor databases, tax filings she'd obtained through separate channels. The accounting appeared to have been prepared with the assumption that no one would be cross-referencing it against anything. It was internally consistent in the way that things prepared by someone who understood accounting were internally consistent. It was not consistent with external reality. She sent it to Dennis at 2:15 in the morning with the message, "I've started. Please see the attached markup. I need your full analysis by end of next week." Oh, she also sent it to Sarah with, "Accounting received. Please prepare the petition for filing as soon as Dennis's analysis is complete. Dennis's full analysis came back in 9 days. He had, in the same 30-page memo with IE appendices format, identified 14 material discrepancies between the accounting and the external records, totaling approximately $280,000 in assets or transactions that were either misrecorded, omitted, or recorded at values that did not reflect reality. He had also identified what he described as an internal accounting issue in the investment account management, where estate funds appeared to have been temporarily placed in accounts that were not estate accounts before being returned, a pattern consistent with what was sometimes called churning, or using other people's assets to temporarily fund your own cash flow needs. If the churning finding held up, it was not just a civil matter, it was potentially a criminal one. She flagged that for Sarah. Sarah's response was characteristically brief, noted. I'll reference it in the petition, but we don't need to make the criminal argument. The court doesn't need that to remove her. Right. The court didn't need to find fraud beyond a reasonable doubt. It needed to find that the executor had mismanaged the estate and that it was in the interests of the estate and its beneficiaries to appoint a replacement. That was a civil standard. It was a lower bar, and it was the bar she was aiming for. The petition was filed on a Wednesday morning in month 12 of the estate's administration. It was 43 pages plus 87 pages of exhibits. Sutton named Celeste Hargrove as the respondent and asked the probate court to remove her as executor on 5 grounds: failure to compile and file a complete inventory, excess executor compensation, self-dealing in the disposition of estate assets, failure to provide accurate accountings, and breach of fiduciary duty in the management of estate investments. Sarah filed it at 9:10 in the morning. By 10:15, Celeste's attorney had been served. By 11, Vivian had a text from a number she didn't recognize that turned out to be from one of Celeste's legal team asking to schedule a call. She forwarded it to Sarah and said, "Nothing verbal, everything in writing." She was at her office, the design studio she ran, looking at color samples for a client project she had genuinely been working on throughout this entire year. All because she had a life to live while the evidence assembled itself, a business to run, clients to serve. She had sometimes thought, in the harder weeks of the past year, that the work was what kept her from becoming only this process. Only the cold architecture of the legal campaign. She needed to be other things also. She set down the color sample card and looked at her hands. The chip on her nail from the car door on the day her father died was long gone, grown out and filed away. Her nails were short now, clean, unpainted. She kept them that way because nail polish required maintenance and she had other things to think about. She called her mother, not Renata, her biological mother, who lived in another city and who had never had any stake in Marcus Liang's estate because they had divorced when Vivian was 4 and they had divided everything cleanly then, and who did not know anything about what Vivian had been doing for the past year. She called her and they talked for 30 minutes about nothing relevant, about her mother's garden and her sister's children, and a restaurant that had just opened nearby that did something unusual with kimchi. It was a restorative call. She hung up and went back to the color samples. The probate court set a hearing for 6 weeks out. This was, Sarah told her, typical for removal proceedings of this complexity. The court would hear Vivian's petition and Celeste's response and any witnesses either side wanted to call. Celeste's response, filed 3 weeks after the petition, was 61 pages. It was written by a firm that billed $450 an hour, and it was very well done in the sense that it addressed every one of the 5 grounds with thorough counter-arguments and, where possible, with alternate explanations for the figures that Dennis had flagged. The executor fees were argued to be within the complexity adjustments that the code allowed. The property sales were argued to have been conducted at arm's length and to represent legitimate market pricing given the specific conditions of each sale. The inventory omissions were argued to be clerical oversights subsequently corrected. The investment account issues were characterized as timing discrepancies in recording rather than actual movements of funds. Vivian read it carefully, and then read it again, and then sent Sarah a 12-point memo addressing each counter-argument with the specific document or data point that undermined it. Sarah read the memo and called her, which she rarely did, preferring email. "You've done this work yourself," Sarah said. "The cross-referencing on the property sales, the corporate structure traces." "Yes," Vivian said. "How long have you been building this?" "Since the executor was appointed." A silence. "You knew when she was appointed." I had reason to believe, Vivian said, carefully. Another silence. You should be careful about the self-dealing evidence, Sarah said, finally. The corporate structure traces are strong, but they'll argue that the connections are circumstantial. We need the expert witness testimony to be airtight. I know. Dennis is prepared. And the Renata conversation? I've asked Renata if she'd be willing to provide a statement. She said she needed time to think about it. Renata had said, specifically, I need to think about whether this is something I can do to Celeste. She had said it to Vivian over the phone, her voice carefully neutral, the neutrality of someone weighing something heavy on both sides. Vivian had said, I understand. Take whatever time you need. I just wanted you to know what you witnessed and that it may be relevant. She had not pushed. She would not push. If Renata gave a statement, it would add something to the case that was already strong enough to win without it. If Renata didn't, the case was still strong enough. 2 days before the hearing, Renata called her. It was early morning before 8, and Vivian was at her kitchen table with her coffee and her laptop reviewing the exhibit list one more time. She picked up on the first ring. I'll give the statement, Renata said. Not, hello, not I've been thinking. Just that. Direct, which was not Renata's usual register, which meant she had spent time landing on it. Okay, Vivian said. I'll let Sarah know. She'll contact you to take a formal statement. Viv? Yes. A breath. She told me it was just good business. The property sales. That's what she said when I asked her once why they were selling so quickly. She said it was good business. A pause. I didn't understand what that meant at the time. You understand it now, Vivian said. I think so. Another pause. I think Marcus would have... She stopped. I know, Vivian said. She meant it. Entered the hearing was on a Thursday in the 10th month of the estate, which made it 14 months since Marcus died. The courtroom was a standard probate courtroom, functional and slightly tired the way civil courts often were, with fluorescent lighting that made everyone look like they'd been awake too long and rows of wooden benches that were slightly too hard for the length of the proceedings. The judge was a woman named Honorable Patricia Morales, who had been on the bench for 11 years and who had the particular economy of manner that long-tenured probate judges developed. She had seen most configurations of family conflict and estate dispute, and she did not perform surprise. Celeste was at the respondents' table with 2 attorneys, both in dark suits, both with the poised stillness of people who bill by the hour and have therefore learned to be still. She was in a charcoal jacket and a silk blouse, professional and controlled, and she did not look at Vivian when Vivian entered the courtroom. That was fine. Sarah presented the petition in 2 hours. She was economical, which was her strength, never adding a word that wasn't earning its place. She walked through the 5 grounds in order, introducing each exhibit with its document number and the specific statutory provision it implicated. Dennis Yu testified for 45 minutes on the financial analysis, and he was exactly what he had been on the phone, precise, unhurried, completely unshakable in the way that people who dealt only in numbers and documentation were unshakable because there was no emotional lever to pull. He said what the numbers were and what they meant under the applicable standards, and he did not say anything beyond that. Renata testified for 20 minutes. She was, as expected, not a dramatic witness. She spoke quietly, sometimes losing the thread and having to be redirected, and her eye contact with the judge was intermittent. But she said clearly, and it was recorded, that Celeste had told her the buyer for the Oakfield property was a group she'd worked with before, and that when Renata had asked about the sale price, Celeste had said that it was good business and that the timing worked for everyone. The timing worked for everyone. Judge Morales had written something when Renata said that. Celeste's attorneys cross-examined. They were thorough and skilled, and they worked hard to establish that Renata's memory was imprecise, that the statements were ambiguous, that a group she'd worked with before was not evidence of anything specific. Renata agreed with some of it and held firm on the core of it, which was the right way to be cross-examined. The second day of the hearing was Celeste's case in chief. She testified herself, which was a choice Vivian had considered. Celeste was at her best in a controlled environment, and her performance on the stand was exactly what Vivian expected. Measured, detailed, expert-sounding. She had explanations for every number and every decision, and the explanations were not implausible, they were just, when set against the documentation, insufficient. Sarah's cross-examination lasted 90 minutes. She had a gift for the kind of question that appeared reasonable on its surface and had a spike underneath it, the kind that moved through the logical structure of the testimony, looking for the moment where the explanation didn't quite reach. She found 6 such moments, and she returned to each of them twice from different angles, never pressing hard enough to give Celeste a clear target, just establishing, for the record, that there were answers the explanation did not account for. The most effective moment came when Sarah walked Celeste through the corporate ownership structure of Meridian Property Group, LLC. She had the documents on the screen, Colorado filings, the registered agent documents, the formation records, and she asked Celeste to confirm, for the record, that she was familiar with David Hargrove. Celeste said yes, he was her husband's brother. Sarah asked if she was aware that he was connected to the entity that had purchased the commercial property at $2.62 million. Celeste said she had not been aware of that connection at the time of the sale. Sarah asked, in the same tone, if she had made any inquiry about the identity or affiliations of the buyer before accepting the offer. A pause. The offer was presented through the listing broker, Celeste said. Did you ask the listing broker about the buyer's identity? Another pause. I received the standard buyer disclosure forms. I'm asking if you specifically inquired about whether the buyer had any personal connection to you or your family. Celeste's attorney objected on relevance grounds. Judge Morales sustained it, but she made a note on her legal pad, and the note was visible to Sarah from where she stood. And Sarah's expression did not change, but something settled in it. The particular quietness of someone who had gotten what they needed from a line of questioning, regardless of whether the last question was answered. The closing submissions were filed the following week. Sarah's was 30 pages. Celeste's attorneys filed 42. Judge Morales said she would issue her ruling within 21 days. It came in 18. Vivienne was in her office when Sarah called. She was looking at a client rendering on her screen, a residential interior she was working on, and her phone rang and she saw Sarah's name and she set down her pen and picked up. The court has ruled, Sarah said. Judge Morales granted the petition on 4 of the 5 grounds. Which 4? Failure to account, excess executor compensation, all self-dealing in the Oakfield and Meridian transactions, and breach of fiduciary duty in the investment account management. She did not find sufficient basis on the inventory ground. 4 of 5. The self-dealing finding. Yes, she found, and I'm quoting, clear and convincing evidence of a pattern of transactions designed to benefit parties connected to the executor at the expense of the estate, constituting a material breach of fiduciary duty. She ordered Celeste's immediate removal and the appointment of a professional fiduciary. She also ordered Celeste to reimburse the estate for the excess compensation she had taken, which is approximately $94,000. Vivienne said nothing for a moment. There will likely be further proceedings, Sarah said. The professional fiduciary will conduct an independent review of all transactions and will likely identify additional claims. The self-dealing finding could be referred to the state attorney's office. There may be civil litigation to recover the undervalued transaction losses. I know, Vivienne said. Vivienne? Yes. You built a very clean case. I've been doing this for 4 years, and I've rarely seen beneficiary documentation this organized. Vivienne looked at her rendering on the screen. A living room interior, warm tones, a very specific shade of amber that she had spent 3 weeks refining. Thank you, she said. She hung up the call and sat for a moment in the quiet of her office. Outside the window, the city was doing what cities did at mid-afternoon in winter, moving, generating its specific textures of noise and light, but indifferent to the particulars of any one person's day. A bus went past. Someone was talking loudly 2 floors below her window. The heat in the building was working too hard, and the radiator was making its irregular ticking sound. She thought about the February courthouse and the rain and Celeste walking past without looking at her. She thought about her father, who had been 67 years old on a Tuesday in October, and who had wanted her to be the executor because he had trusted her, and because he had known, in the way that parents who paid attention knew, that she was capable of protecting what he had built, and who had not gotten the signed codicil done in time, which was the small administrative failure that had set everything else in motion. She thought about the first life, the way it had felt to sit outside that courthouse with the rain coming through her coat, and the folder of documents she could no longer do anything with on her lap, and the understanding arriving slowly, the way bad understanding always arrived, that she had lost. She did not feel triumphant. That was the thing about building something this way, in this cold and patient and methodical manner. You didn't arrive at a feeling of triumph because you had not operated from passion. You had operated from knowledge, and knowledge didn't reward you with a rush at the end. It just resolved, the way a calculation resolved, into the answer you had been working toward. She closed the rendering file and opened a new one. She had 3 clients with active projects and 1 new inquiry she hadn't responded to yet, a referral from another firm, a renovation in a brownstone on the north side. She opened the inquiry email and read it, and replied briefly that she would be available for an initial consultation the following week and that she looked forward to hearing more about the project. Her phone rang again. She looked at the screen. Celeste. She let it ring. 4 rings. 5. On the 6th ring, she picked up. The sound of Celeste's breathing was the first thing she heard. Controlled breathing, the kind that required effort to maintain. "Vivian?" "Celeste," she said. A pause that lasted approximately 3 seconds. "I've just heard from my attorney." "I imagined you had." "I need you to understand," Celeste began, and then stopped, and the stop was interesting, not because it sounded like the beginning of an explanation that had run into the wall of knowing there was no explanation that would matter. "I don't need anything from you," Vivian said. Her voice came out the way she wanted it to come out. Not hot, not cold exactly, level. The kind of level that was itself a statement. "There was no malicious intent," Celeste said. "The way the transactions were structured, the court found what the court found," Vivian said. Another pause. She could hear, in the background of Celeste's call, what sounded like a kitchen, some domestic ambient noise, a faucet, a door. It made Celeste suddenly present as a person in a room in a house, rather than as a concept in a legal proceeding. Vivian noticed that, and held it briefly and let it go. "Is this what you wanted?" Celeste asked. And there was something under the question that was not quite what Vivian had expected. Not exactly anger, something more exposed. The genuine incomprehension of someone who had made a calculation and gotten the outcome wrong and couldn't quite map the failure. "You let me take the executor role. You never pushed back. You were cooperative. And then this." "Yes," Vivian said. A silence. "You were building this from the beginning," Celeste said. Vivian did not answer that. "From the very beginning," Celeste said again, quieter. "Celeste," Vivian said, "the professional fiduciary will be in touch about the transition of records. I'd encourage you to have everything organized and ready." She ended the call and set her phone face down on her desk. Outside the window, the bus was gone, and the person talking loudly had moved on, and the radiator ticked, and the city continued its afternoon at whatever frequency cities maintained, regardless of what you were doing inside them. She picked up her pen and her legal pad and wrote the date, and below that wrote, "Call Sarah Ree, timeline for professional fiduciary transition. Call Dennis Ree, scope of independent review support." Then she set the pen down and looked at the amber on her screen, the particular quality of the warm light she was designing into someone else's living room, and she thought about what shade her father had used in his study, the room where the lithograph prints had hung for 20 years. And she made a note to include that in the professional fiduciary's first meeting. Those prints were still somewhere. They needed to come home. She picked up the phone and dialed